Whoever put that in the complaint just screwed them. He just made them debt collectors. It's without question. It says right there. That's a very common thing that happens. Even though the person got insurance and it got paid off, they still get sued. I sent these 3 letters. Either the response is good for you or they didn't respond, even better for you. I'm going to show you a neat thing they did and screwed themselves. Hey, it's your old buddy Brian Parker coming at you with a very interesting video. This comes from another sort of a case study and a comment to our membership site, Killdebt.com, that wanted me to do a follow-up on the Capital One Discover merger. They had received a lawsuit and one of these merger letters, they're just a letter, that's attached to the lawsuit to justify Cap One saying, we own the debt now as of May something 2025. So I'm going to show you how to get around that, how to beat the merger, and some cool ideas I had. Remember, a merger does not create ownership in anything. It only transfers what exists. That's key, especially when you think about securitization. So if you've been sued by Capital One claiming they took over your Discover Card Bank, I've got a number of cool things you could do. As I was writing this today, I started getting ideas and I came up with some great letters and a great cheat sheet. You know I love my cheat sheets. Anyway, and they're all for you and they're embedded in ParkerGPT at Killdebt.com. I believe when this video drops, 2.0 will be live. It's Sunday. We are working on it right now to bring it to you. I hope it's worth the wait. I think it will be. Let me tell you what's attached to this video for you that will also be embedded in ParkerGPT. So hit the prompt, you get the letter. So I've attached a motion to compel. A motion to compel, well, I came up with this great motion idea to help you win your Cap One Discover merger case. Also, a Freedom of Information Act letter on the merger, a letter to Cap One for information on the merger, a letter to the OCC, Office of the Comptroller, that is supposedly the letter writer that's attached to most of these Cap One Discover Bank lawsuits that have been coming out. My show notes, a lot of work there, and a cheat sheet, as I said, to analyze the Cap One Discover Bank merger case. So you take this cheat sheet, take their lawsuit, and just check off what they did wrong based on how I'm showing you. It's a nice cheat sheet to speed up the process, and I think you'll like it. Like, love, and subscribe to this channel. We're going great guns now, both on our membership website and our YouTube channel. We find that our YouTube friends come over to our membership site, Killdebt.com, and more than ever, you should be there with the 2.0. So 6 possible things I want to show, or basically have Cap One prove when we face one of these lawsuits. Shazam. They got to prove they own your specific debt. Not a debt, but your specific debt. Impossible in the current document I'm seeing. Proof of the merger. Well, there's a letter attached, Your Honor. It says Cap One Debt Collector Attorney. You say, well, that's a letter, and I'll show you why that's not so good. Your original agreement with Discover. I'm going to show you a lawsuit today. It's a typical lawsuit with an interesting twist on how you beat the average Cap One Discover lawsuit. Documentation of the transfer of your debt. They got to show, just like any other case, to meet their burden of proof that your debt is the one they're collecting upon. Proof you owe the amount claimed. They got to show. They can't just say, well, I owe $6,000. Prove it. Proof the debt was not securitized. Discover Bank securitizes all their stuff. So think about that layer of proof. Not only have they got to prove they own your specific debt, it wasn't securitized, which it was. And I added a number 7, even though I said the 6 possible things. Cap One is a debt collector acting as a creditor. You'll see. So let's see this letter, this famous letter that gets attached to debt collector lawsuits from Cap One around the country. Shazam. And that's from the Office of the Comptroller of the Currency. And essentially they're saying, yep, the merger happened, but maybe it didn't. So nowhere does it say Capital One automatically owns your specific debt. Here's the sample of this great lawsuit that is the typical Cap One lawsuit, Shazam. And that's 2 counts of breach of contract and account stated. Here's the second page, Shazam. That's the most important page to me. You'll see on 12, it says a final statement was sent to the defendant to which defendant did not object. Hang in there with that. You can see they're claiming $6,672.63 was owed. Here, Shazam, is the agreement, is the actual cardholder account statement, the last one the person received. But this is kind of unique. Look at this. It shows payments and credits, internal charge-off of $6,672.63. Does that ring a bell? That's what he's being sued for. Balance owed, 0. You can see it right up there. It's not just a charge-off. It was some payment or credit internally charged this debt off. What I think happened is the debt collector or the attorney saw, oh, I can still sue on a charge-off. This ain't that, and we'll talk about that. So again, the wherefore clause is on the end of every count in a complaint that says, wherefore, in this case, such and such person is owed such and such amount from the such and such defendant. Here they're claiming $6,672.63, the amount that was not just charged off, but charged off with certain internal credits. That usually to me means someone defaulted on their debt, but they had insurance and the insurance paid it up. That's a very common thing that happens. Even though the person got insurance and it got paid off, they still get sued. So the statement shows payments and credits of $6,672.63. This indicates the credits were applied to the balance, and the balance of 0 comes after those credits. So it's not really a charge-off. It was credited as a payoff. So this is a violation of the FDCPA and your state collection statute if you're being sued for something that you don't owe. That's very clear. Charge-offs normally don't eliminate the debt, but in this case, it's documented that these were credits that equaled the full balance. So that, to me, tells me that that insurance paid off this debt. So look at, again, number 12, Shazam. Defendants used or made payments on the subject account. A final statement was sent to the defendant. That's the statement you just looked at that said it's 0, to which defendants did not object. What that means is, you've seen my video on the Fair Credit Billing Act, Shazam up there, and it's sort of reversed that. I always counsel in my FCBA PRISM videos, approaches, advice, education to you, that you file a dispute under the FCBA if you see any problem with the account statements. That's why they put that statement number 12. It's a throwaway. It's put into most collection lawsuits so that you can't use the FCBA because it says you did not object. The FCBA not only allows you to object, but it ties up the case, and until an investigation is done that's premised on your sending the investigation letter that's attached to my FCBA video, they can't do anything, including collect on the debt. So their number one problem is they have a securitization problem. Let's call it the securitization problem. Discover securitized most of its credit card receivables and sell the payment rights into a trust called the Discover Card Master Trust 1. Once a receivable is sold through a trust, Discover doesn't own that debt anymore. Discover is only a servicer or a collector for the trust. So after the merger, nothing has been shown to prove that Discover sold anything to Capital One, especially if it's in a trust. That means at best, Capital One can only be a servicer, which is not an owner that they claim to be by merger. So under the FDCPA, that's a potential misrepresentation. So I'm telling you all these things to wind into some great ideas I had. Look at the complaint. On May 18th, 2025, Discover Bank merged into and became part of Capital One. As a result of the merger, Discover no longer exists. Go online and put in Discover Bank and you'll see they certainly do. They exist and they're still promoting new business. Go check it out. But the debt was likely securitized. So I'm going to show you a neat thing they did and screwed themselves. So under the FDCPA, that's a potential misrepresentation. So I'll show you what we're going to do with that information I'm promising you. They are claiming a breach of contract. So we have a breach of contract problem. Look at their complaint, paragraph 9. Per, or usually pursuant, the terms and conditions of the agreement, defendant borrowed money and were to repay the amount financed plus fees, blah, 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 in the terms and conditions, a copy of which is attached to Exhibit A. No such copy of Exhibit A attached, no agreement. And even when they do, it's not the agreement. But in Florida, this is a Florida lawsuit, by the way, but it can be anywhere. And most states, if you're suing on contract, you have to attach that contract. Pro tip, quickly, always check whenever a debt collector writes a lawsuit and said, pursuant to Exhibit A, pursuant to Exhibit B, you'll be so surprised that the thing they're pursuant to or referring to isn't there or is the wrong thing. The merger letter problem, Shazam. The merger letter says the Office of Controller of the Currency, the OCC, approved the merger of Discover Bank and Capital One effective May 18, 2025. But the letter only proves one thing, that a merger was approved. However, the letter also states, Shazam, if the combination does not occur as represented in your correspondence of May 7, 2025, this certification must be returned to the OCC. Definition? That's not proof that a merger occurred. It's conditional. So it's not certain, it's just conditional. It does not prove that Capital One owns your, because that's what it's all about. You're being sued. They got to prove they own your Discover Bank. Don't lose sight of that. So a merger does not create ownership. It only transfers what the predecessor owned. Especially if it's securitized, they ain't owning or selling anything. So cool thing, look at paragraph 6, Shazam. This is an attempt to collect a debt, and any information obtained will be used for that purpose. It's a Cap 1 lawsuit for Discover. If they're debt collectors, they have to be collecting for a third party. It's a trust. That is a hint and a half for you that it's absolutely a trust. A creditor cannot use a debt collection statement, mini Miranda warning, or anything else of the FDCPA because they are not regulated by the FDCPA. So whoever put that in the complaint, I believe the attorney, just screwed them. He just made them debt collectors. It's without question. It says right there, we're collecting a debt and any information obtained will be used for that purpose. Keep a hold of that. So only debt collectors can state that. At a minimum, Capone is using debt collection to scare the debtor, and that's a violation of FDCPA. And in that case, you're treated as a debt collector when you use the debt collection rules against somebody. So Shazam, Capone still has the burden of proof to show the following. Specific proof your debt was transferred to Cap 1. Discover actually owned the account before the merger. The account wasn't sold or securitized. The merger really happened. That's the OCC proof. Remember those letters I've attached. Remember, I've attached a Freedom of Information letter, a Cap 1 letter, and a OCC letter for you to send and say, hey, send me the merger documents. Even if nobody responds, and likely one or two, especially Freedom of Information Act. If you don't get anything you want from Freedom of Information Act, it has statutory attorney fees and damages, so they're likely to respond. And when they do, they don't care about Cap 1 or you or anything else. They're just going to produce the documents because that's the law. That can help you. So you're going to get a response to that. If the other guys don't respond, that you can show the court, hey, look, I'm trying to get the proof here, and I'm going to show you why that's a cool thing. The account transferred into the Capital One records. That's got to be proven too. So here we go. Here are the 4 options you have after you have created your counter affidavit. So everything I just told you goes into your counter affidavit, which is going to be attached to your answer. But is it? Check this out. So you do create the counter affidavit. Remember my rule, you gotta have a counter affidavit. So your option number 1 here is to follow your answers. And the defenses would be obviously Plaintiff's own evidence shows a zero balance, failure to attach required contract documents. If you're going to say breach of contract, you got to show the contract. A lack of standing, no proof of account ownership, your debt by Cap 1. A payment satisfaction, it looks like it was paid off. Failure to state a decent cause of action. I only see 2 counts, all relying on paperwork they don't have. So here are 2 cool options. File a motion to dismiss. Remember I did that video? What should I do? Answer the lawsuit or file a motion to dismiss? There you go. Go check that baby out. It's cool. Got a lot of people love that. You don't need to file an answer under the rules yet. When someone sues you, you have 2 options in most states. File a motion to dismiss because you're just saying, hey, you kidding? There's nothing here. Make them give me something or make the case go away, judge. Or 2, you can file an answer. I think you file this motion to dismiss. You've got lots of room and an absence of documents where you can safely file a motion to dismiss. And at the very minimum, the court and the rules require they have to produce the documents that you're already sending to the Officer of Comptroller of the Currency, the Government on the Freedom of Information Act, it's SEC, and Cap 1. You're really loading up with my video and my letters attached to the video, Killdebt.com. Make them prove their case. They will be ordered to prove their case or produce the documents. The case will, like I've showed you in that video, should I answer or should I do a motion to dismiss the video? They immediately got back to me and said, well, we'd like to settle. So a motion to dismiss would include the following. Let's put it up there. Plaintiff's exhibit shows the 0, failure to attach exhibit A, the contract, no proof of standing, no ownership proof. Debt was securitized, so there must be proof the debt was sold from the trust. 2, Cap 1 on top of a transfer, not just the servicing rights. Merger paperwork is required. So when you do a motion to dismiss, generally the court will go, Parker, it's too early for that, but I will make them do this because they cut the baby in half, the Solomon rule. So they will make them produce the documents that they generally don't have pursuant to your debt. Focus in on that. They must prove your debt, your contract. Option number 3. So if you're already in the middle and you're looking at this video going, oh, Parker, I've already answered or already done whatever, I'm in the middle of it, do a motion to compel. File a motion saying, I want proof of standing. I want proof of the bank merger and securitization. I sent these 3 letters. Either the response is good for you or they didn't respond, even better for you. And I want the following: the OCC merger letter proof, the ownership by account chain of title from the trust, from Discover Bank to Cap 1, your specific debt, that's called proof, burden of proof, and the securitization defense. You can drop this straight into a motion compel. I'm attaching it to this video. You're going to drop all of your caption and your proofs. I've already put the letter proof in there so that you can show what you want and force them to produce. If you're already in the middle of this case, it's a great idea. Or option number 4, let's put it up there, the counterclaim. Because they are claiming to be debt collectors when they're also claiming to be creditors, you can sue them under the FDCPA on a counterclaim. Because they're falsifying debt amounts and lack of proof, you can sue them under the FDCPA and your state violations. As I said in my last video, state violations sometimes are better as far as damages and the way you can put a hurt on them under your state collection lawsuits. So look those up. There's just great settlement potential once you file these things because they don't want to give them up. They don't want to give them to you. So trust me, you'll settle that case much better and quicker. Each violation could be thousands of dollars, pecuniary damages, which means just through the roof, maybe triple damages in some consumer protection states, attorney fees and costs, just you got them. Now, I've got a checklist, Capital One Discover Merger Defense checklist attached to this lawsuit, attached to this video. You'll be asked, and it'll show you ways to check the evidence, verify missing documents, securitization defense, the merger problem, the missing contract, the burden of proof, they must prove 7 ways. I go over that, but it's attached to the video here at Killdebt.com. It's 2 pages. It will square you away. So You can take the lawsuit and you'll know every possible way to beat them with their own documents, or even in this case, an absence of documents they have to have to win. And I think you can do quite well with this video and these great documents. At Killdebt.com 2.0 should be here now. I hope it is a great thing for you. That we also have added new cool things to ParkerGPT. Check out the My Briefcase. Everything you do on the site goes into your own briefcase, including the searches that you do. The searches that you do with Parker. I love the expression, go do the voodoo that you do. And I want you to do the voodoo that you do. Special to you, it's going to be your own briefcase. And when you go into ParkerGPT, it's going to save all your chats, we call it, or save all your searches. So you never miss, and you go, oh, I know I did that. I just did it myself. I was on ParkerGPT and I'm trying to find stuff I'd done. The good thing about that is we're creating an option inside your briefcase so you can make your own checklist, like I do, on your case. You can create a checklist in the briefcase of Killdebt.com 2.0 on your case. Everything you do, all your video searches, you can bookmark every video, all your searches, all the documents you use. You have a calendar, everything. There's so much there on Killdebt.com 2.0. You're gonna love it. Look for the briefcase, look for it all. Thank you. Bye-bye.